many do we need for quorum? 4?
What was that?
How many do we need? 4?
No.
This one's here.
favor?
Aye. Any opposed?
Nay.
All right, so the next thing on the agenda then is citizens to be heard regarding items not on the agenda. There's no one in the audience today, so I guess we'll move on to the business of the day. The first new business item is elect the chair and the vice chair. You remember that Ms. Grayston has been the chair for the past 2 years. Pursuant to your rules of procedure, she cannot do it any longer. There's a 2-year requirement. So we would need a motion on the floor to elect the chair, and then we follow that by election of the vice chair.
Do we have a motion to elect a chair?
Any nominees?
I nominate him.
Taylor nominate Baker.
I second.
Okay, any other nominations for chair other than Mr. Baker? There being no other nominations, then no motion is required. Mr. Baker, you've been appointed. You are now in control of this meeting. You are the new chair. So the next item on the agenda is the vice chair, and I'll leave it to you.
Yes, we'll open it up now to nominations for vice chair.
Are you looking?
And,
Are you looking
and
at
I will
me?
tell you that I cannot make any motions, so it's going to have to be made by,
I nominate Miss Lane.
No, I was looking at you to nominate you.
do we have a second?
No.
I'll second.
Any other nominations? There being none, congratulations. You're the vice chair.
Item 4.2.
We are now going to review the nuisance abatement ordinance and sunshine law, and our attorney Trask will lead us through that.
Thank you. I know that you've been through this before. We did this a little over a year ago. I'm just going to try to briefly go through it again. We're doing it for a couple of different reasons. One is that it's been over a year, and the other is that it's always good as a refresher. And then if there's any questions that have come up within the past year, hopefully I'll be able to answer them for you. And please remember, just as I mentioned the last year when we were here, is that whenever you have a question, please feel free to call me. You don't have to wait to a meeting to ask that question. I am the board attorney as opposed to the city attorney. So I'm here for you. So let's start off with the ordinance itself. You'll remember that in March of 2015, the city adopted an ordinance. That ordinance was 8692-15. That's the ordinance that specifically created the Nuisance Abatement Board. The Nuisance Abatement Board, you'll remember, is here for the purposes of hearing complaints regarding nuisances that may be set forth in the statute, Chapter 893, and I'm going to go through some of those specifics as we go through the rest of the ordinance. This board is made up of 7 board members. That means that we have to have at least 4 of you here to conduct any business. We have 4 today. The Nuisance Abatement Board has a couple of different powers. Those powers are provided to you in the code, and also they're mentioned in the statute. The first thing is that you have the right to adopt your own rules of procedure with regard to conducting your hearings. You've already done that. We've used some of those rules earlier to determine whether we need to adopt or appoint a chair and a vice chair. So you do have those rules in place, and you can amend them from time to time if you'd like to do that. You also have the power to subpoena witnesses to this hearing. You have the power to subpoena evidence to this hearing. The board itself is going to hear complaints or can hear complaints alleging that any place or premises that constitute a public nuisance, upon clear and convincing evidence as to one of the following different types of nuisances. So these are the types of nuisances that you will hear. The first one is, on one occasion, as the site of the unlawful possession of a controlled substance where such possession constitutes a felony, and that has been previously used on more than one occasion, all within a 6-month period, as the site of unlawful sale, delivery, manufacture, or cultivation of any controlled substance. The second is, on or more than 2 occasions within a 6-month period, the site has been used in violation of Florida Statute 796.07. That's relating to prostitution and prostitution-related activities. The third is on one or more occasions within a 6-month period as the site of an unlawful sale, delivery, manufacture, or cultivation of any controlled substance. The fourth is by a criminal gang for the purpose of conducting a pattern of criminal gang activity. The fifth is on 2 or more occasions within a 6-month period, the site of a violation relating to stolen property. And the last one in the code is on more than 2 occasions within a 6-month period, any pain management clinic as described in the statute as the site of a violation of something related either to assault and battery, burglary, dealing in theft, robbery by sudden snatching, or relating to the unlawful distribution of controlled substances. So you have a wide variety of things that can possibly be considered as a nuisance, and those are the things that you may hear in the future through hearings that are brought to you. As you remember, the process starts with the filing of a complaint. The complaint is filed by the prosecuting attorney, that is the city attorney. In that complaint, there are some very specific things that the city attorney has to set forth. I'm not going to go through those details, but there are some requirements that the city attorney would have to include. Once that complaint is filed, a notice of hearing is issued. That notice of hearing is provided to the respondent. There are some time frames that has to be done. I don't want you to get caught up in that, but there is a time frame that the notice has to be received by the respondent in order to be receiving due process for the hearing that would take place. The code also provides that once you conduct this hearing, you can receive evidence pertaining to the conduct described in the complaint, that each owner and each respondent that is a part of the complaint has the ability to appear before the board in person or through legal counsel and offer evidence or a defense or in mitigation of the complaint itself. The prosecuting attorney is the one that presents the evidence on behalf of the city, and all parties involved shall have the opportunity to present evidence and argument on all issues and to conduct cross-examination and provide rebuttal evidence. At the conclusion of the hearing, as you've seen in the past, there is a order that is prepared. That order will contain findings of fact based upon the evidence that's presented, and it's those other items that are part of the record. Once that order is entered, it is in existence for 1 year period of time. In that order, the board can impose a fine not to exceed $250 a day for each day the conduct occurred, or if it's a reoccurring violation, not exceeding $500 for each subsequent finding of recurring public nuisance. This board also has the ability to award reasonable costs associated with the investigation and the hearing, including attorney's fees, investigative costs, and costs of recording the order. The only caveat is that the total fine imposed is limited to a total of $15,000. The board retains jurisdiction for 1 year after the entry of the order in order to modify the order if necessary. Otherwise, it expires after a 1 year period of time. The order itself is normally recorded in the public records. It becomes a lien on any non-homesteaded real property. The property owner is then, if it's foreclosed by the city, have the obligation to pay all costs, including reasonable attorney's fees and associated costs with regard to recording of the orders. Just a reminder, though, this is only on non-homesteaded real property. Homesteaded real property is not going to be subject to the lien pursuant to the statute and the city's code. That's a basic overview of the ordinance for the Nuisance Abatement Board. Is there any questions on the Nuisance Abatement Board code provision before I move on to my next little topic? Okay. As you remember, when I mentioned to you last year, I wanted to go over a couple of different statutes, one of which is the Sunshine Law and one is the Public Records Law, and remind you that in 1968, when the Florida Constitution was changed, there were a couple of provisions that were added that specifically addressed access to public records and open meetings, and as a direct result of that change in the Constitution, there were a couple of statutes that were adopted. and those statutes are the Sunshine Law and the Public Records Law. I want to talk to you about them independently of one another. Today I handed out a little packet. The packet itself consists of three statutes, and the first one I'm going to talk about is the Sunshine Law, and that is the one that's marked at the very top, maybe the top quarter page, 286.011, public meetings and records, public inspection, criminal and civil penalties. That's the statute that creates the Sunshine Law. You remember that that's a requirement that provides that any two board members of the same board cannot talk or communicate about a matter that will eventually come back before this particular board for action. Those would include not only conversations, but emails, texts, social media, Facebook, TikTok, whatever it is that you use, blogs, any other type of form of communication. You need to remember that you cannot be talking to any other board member of this board about an item that will foreseeably come back before this board for action. In addition to that, under this statute and the Attorney General opinions that have been issued relating to the Sunshine Law, is a requirement that you not use a liaison or middleman to transmit information. That is also considered to be a violation of the Sunshine Law. So, for example, if Mr. Baker asked me to tell Ms. Taylor something about a hearing that's coming up, not only would Mr. Baker be violating the Sunshine Law, but I would, as well as Ms. Taylor when she responds to it. So we can't use a third person as a liaison to transfer information back and forth. When you look at this statute, it's basically requiring three things for the Sunshine Law to be applicable, and that is that the meeting has to be open to the public. That's the first thing. You can see we're here in this meeting, and we're at the library, and anybody can come in the door. The door is not locked. It's open to the public. It's easily accessible. Nobody has to go through a metal detector. Nobody has to be asked their name or their address or telephone number or anything like that. They're just able to come in. So it's open access. And that would be throughout the entire time that this board is meeting. So in other words, we can't have the doors open and then locked once the meeting starts. The second requirement under the Sunshine Law is that for a reasonable notice be given of the meeting. You'll realize that the city clerk had given out the packet about a month ago. There is, even though, that's great, it is not necessary to be a month in advance at any reasonable period of time, and that depends upon the circumstances, but I would say at least a week prior to any meeting would be reasonable under the statute, and so you will see that the package will go out and the public will be given notice of the meeting at least that period of time. The last thing is that every one of these meetings, there are minutes taken, and the minutes are made available to the public once they've been created. They can be provided in summation or draft form as well as the final approved form, but minutes have to be taken and promptly recorded. So what happens if you violate the Sunshine Law? If it's an unintentional violation, it's a $500 fine. If you do it intentionally, it's not only a $500 fine, but it's a possible punishment of up to 60 days in jail. So it's really, really important, not only for the purposes of not getting yourself in trouble, but also just so that you know, any action that takes place in a meeting that wasn't properly noticed and minutes weren't taken, any action at that meeting would be considered void and non-binding. So that's a bigger part of the picture for the city. We don't want anything happening where we'll have to do everything all over again. So there are consequences to both the city and you if there's a violation of the Sunshine Law. Are there any questions about the Sunshine Law? I know I did this last year, so I tried to move through it quicker. Any questions about the Sunshine Law? Okay. So in the packet, I've also provided you the statute for the Public Records Law. That's the one is number 119.07, inspection and copying of records, photographing public records, fees and exemptions. That's the 3-page statute that basically provides that you as a board member, if you receive Any type of documentation for anyone, it could be considered a public record, and you have an obligation as the custodian of that record to retain it. So why is that important? Well, if somebody wants to see it, you have then the obligation to produce that public record. And as I mentioned last year, I think that the best thing to do is if you receive something from the public and it didn't go through the city clerk or the police department or another staff member, that you have an understanding that, that you're probably the only one who's receiving it, and so you are the custodian of that record. But you can provide that record to the city clerk for retention, and you don't have that obligation to retain it any longer. And that's my suggestion to you. If you receive, for example, an email from somebody that wants to talk to you about a case that you either going to hear or have heard, and they want to give you some input on it, it's best that you give that to the city clerk. In addition to that, there's probably an obligation to disclose it to the other board members, the information that you receive, so that they receive the same information about an upcoming or past hearing. So, again, my advice to you is if you receive something like that, provide it to the clerk, and then you don't have to retain it. You'll note that in the statute itself, I had mentioned that it's actually 4 pages, I think, the way it's printed out. I also provided you with another statute, 119.071. These are the exemptions for the public records. You'll notice that that one is about 20 pages in length. So you got 3 pages of, this is the statute, and you got 20-some pages of exemptions to the statute. The exemptions are things that you're probably already aware of, and like I mentioned last year, things like active criminal investigations, documents that would reveal who a victim is in a crime, medical information, social security numbers, addresses and telephone numbers of protected individuals such as firefighters, code enforcement officers, police officers, special magistrates, city manager, human resource officer, those types of people. Those things are protected, so we would not disclose that information. If somebody was to make a request for a public record to you directly, again, my advice to you is immediately provide it to the city clerk. The city clerk has an obligation to do a couple of different things. That is to acknowledge that the request has been received, and that she would start gathering any documentation, and probably if it is a substantive or huge request, provide some type of invoice for any extensive work that is necessary to be done to do an extensive search. If it is something fairly simple, then normally the cities that I represent, they just produce that documentation, don't necessarily charge who is asking. But if it's an extensive search, then the city clerk will need to deal with that. So again, it's very important to keep in touch with the city clerk when you get either a request or a document itself, so that you don't have to retain that in the future. So that's my short discussion on the public records law. Any questions about that particular statute or statutes? Okay. The other thing I've given you is this little Florida Commission on Ethics Guide to Sunshine Amendment Code of Ethics for Public Officers and Employees. That is the same document that the city clerk has provided to you in bigger format. It's much easier to read the one that is in your agenda backup, but I wanted to give you the pocket ones because I normally carry one of these around. What is the purpose of this? It's for a couple different reasons. One is it gives you a basic understanding of some of the ethics laws that have to be dealt with, and disclosure forms, such as the Form 1 that you have to file as a member of this board. And it's my understanding from the city clerk, each one of you have already done that. Thank you. And there's also a requirement for gift disclosure. If someone was to give you a gift as for the purpose of, whatever reason, if it's over $100 in value, you have to disclose that. There is some requirement on how to do that in this little pamphlet as well. If any of those things actually happen to you, I just ask that you reach out to me or the city clerk, and we'll lead you through the path of whatever you need to do to handle that gift if you receive one. So that's my quick review. Since we did it last year, I'd be happy to answer any questions for you about either the ordinance, the Sunshine Law, the Public Records Law, or the little pamphlet. Any questions? Okay, thank you. So, Mr. Chair, it's back to you.
Now we will open the meeting to any staff update that there may be on the nuisance abatement process.
Good afternoon. My name is Lieutenant Stephen Wanos with the Clearwater Police Department. I'm in charge of District 2, which we're currently in. It's from Keene to the water's edge, Union, south to Bel Air.
Oh, you got it. Is it on the screensaver?
It is not. Something is playing. There we go. Thank you, ma'am. So here we are at District 2 nuisance properties. The first one that we have is 110 South San Remo. The owner is Horace Kinsler. They were first given their letter mailed to them on 6/7 of 21 after a narcotics search warrant for sales and possessions of narcotics. The first meeting was held by my predecessor, Lieutenant Dean, on 6/22 of 21. And the owner of the property said that they subsequently evicted the tenant that was related to that search warrant. Since that initial meeting, a narcotics case was made by the patrol units and a warrant arrest was made at the property, but no additional sales of narcotics have been made. At this time, the nuisance property is going to remain open and active as a result of some intelligence that we have gathered. I think it's prudent to keep it open. The next one on our list is 900 North Betty. The owner is Geraldine Burt. Initially, the letter was mailed on May 4th of this year to her daughter Sylvia Burt. Sylvia has thus far refused to meet with anybody, including myself. I've made numerous attempts to meet with her. She refuses to meet with us. This property, nuisance property, was a direct result of PCSO search warrant for narcotic sales. Ironically, her mom, Geraldine, lives directly across the street, and I met with her on 6/27 and learned that she had been in the hospital at the time and was unaware of anything that took place. I provided her the letter for the nuisance abatement in person, and she advised that she was the actual property owner. She showed me the actual deed for the property, which she had a photocopy of on her person, listing herself as the primary and her daughter Sylvia as the third person listed on the deed, and she is responsible for all activity and all financial obligations for the property. And to date, there's been no modifications to the property, and there have also been no cases subsequent to this. Next we have is 1913 Coles Road. The owner is Beverly Sido. I spoke to her as recent as 45 minutes ago. Her property was initially sent a letter May 17th for a narcotics search warrant again, and the first meeting was held by Lieutenant Dean on the same date. To date, none of the suggested remedies appear to have been implemented, as you can see by the front of the residence there. There have only been 2 calls for service at the residence. One was a suspicious incident, and the other one was a self-initiated field interview report conducted by a police officer. On the 23rd of August, I spoke with Ms. Sido, and she advised me that she had sold the residence and was supposed to close on 8/31. I called her at roughly 2:45 this afternoon. She advised that that has not taken place, and the closing has been pushed off till the 9th, which would be this Friday. So we'll keep our fingers crossed that that takes place. 1295 Santa Rosa, specifically apartment number 15. I met with the property owner's agent, which is Mr. Rabbi. I'm not sure if I'm pronouncing it correctly. The letter was sent on 6/10 after a narcotic search warrant was served as a result of narcotic sales. On 6/24, I met with Mr. Rabbi and the property owner at the property, made several suggestions to include adding lighting, adding cameras, evicting the tenant for number 15. At that time, I learned that the resident of number 15 had already been evicted prior to the execution of the search warrant, so that portion of the problem has already been handled. And as of 8/23, a blanket trespass authorization has been set up at the property, which gives police officers the ability to trespass individuals that have no legal standing at the property at the request or on behalf of the property owner. And there's some additional lighting in the top that appears to have been added, and then there's the posted sign in the front parking lot advising anybody in there that officers have the legal ability to trespass. Next, we have 1465 Pierce Street. Ms. Hinton, Tracy Hinton, is the property owner, and she was sent a letter on 7/5 after narcotics sales were conducted at the property and a search warrant was executed. I had a meeting with her on August 20th. During that time, she was given some suggestions to improve the conditions of the property. I was asking for some additional lighting. However, she advised that she's an absentee owner, has no intention of living or remaining at the property, and she is actually also looking to sell the property and move on. As a remedy, she has added the trespass authorization, which you can see in the front left corner over here. She has removed any drapery or blinds from the front window here, and she leaves the interior light on as an ability for individuals and police officers to see that nobody's inside. She lives nearby, but only temporarily. She plans to return to, I believe it was Georgia. 207 Pennsylvania. Miss Kimberly Johnson and other family members are the property owners at this point in time. The property appears to have been handed down to them. This has been an ongoing problem for the police department with regards to narcotics sales from this specific residence. On 8/3, after several narcotic sales and a subsequent search warrant at the residence, they were sent a letter. I met with them on 8/19, and Ms. Johnson, as well as I believe it was 4 other family members, met me. We discussed remedies. The entire family was on board with changing the culture of what was taking place at the property. They agreed, and on their own, they decided to remove a 6-foot-high wooden fence that had been covering the majority of the property and was used to shield and blanket some of the illegal activity from view of the street and from law enforcement. And they were replacing it with a roughly 3 or 4 foot tall lattice-style fence. And on their own, they are going to include and add surveillance cameras, which are going to be monitored by Ms. Johnson and other family members, and they're going to contact us should any observable criminal activity take place. This is another property where it's basically absentee owners. No one actually resides there, and Ms. Johnson and the other family members have agreed that no one should be at the property with the exception of hired contractors who are there to be working on the property. She has contacted us, and she's also signed the blanket trespass authorization form, and a sign is on its way to be established there. And she has already started calling us when people are at the property. So it appears as though this time they are taking it very seriously. And these are some of their makeshift things. The little lattice fencing there, that is replacing what was a 6-foot-high fence, and like I said, shielded everything from our view. And basically, it was a open air drug market within the yard there. Lastly, we have 1929 Shenango. It's owned by Three Partners LLC, which is actually one partner, Helen Kloskowski. She was mailed a letter on 8/3 after narcotic sales and a subsequent search warrant. I spoke to Ms. Kloskowski by phone. She is out of town for several months and was unaware that we had actually mailed her the property, or the letter. She advised that it was most likely her doorman at her condominium association that signed for said letter, and she was unaware of it. We discussed some remedies and things that we would like to see happen, and right now she's a little reluctant to evict the tenant, and I have not physically met with her because, like I said, she's out of state for the next couple of months. Before I conclude, we do have one little bit of positive news. We had 1405 Laura Street, which has been on our list for quite a while, and we were able to remove it just at the end of the last month. It appears as though we've had some compliance and there's been no additional problems at that location.
Good afternoon, everyone. I'm John Connor. I'm in charge of District 3, which is Keene, east to the bay. Same boundaries, otherwise north and south. The one property I do have in my district is a Days Inn. That's at 2940 Gulf to Bay. The owner, Jay Patel, literally just bought it in November of 2021, so he's a new owner. I did, as soon as he was sent the letter, he called me immediately. I had a meeting 2 days later, and with him and his general manager, Casonia Brothers, and they were very receptive to everything we spoke about, and actually we're ahead of the game on a lot of it. If you can tell by the picture and driving around the property, if you've ever been there, it's well kept. The bushes are manicured. He currently already has 6 surveillance cameras on site, and he plans on installing more. Another one of my suggestions was the list of problem tenants, and he already had one. In fact, he let me take a picture of it, and he has 4 reasons: if they're disruptive, drugs, prostitution, or they break something while at the property. So they already had that, and it was already pretty much filled out. So they've been abiding by that for quite a while. I subsequently met with our narcotics sergeant, and there's been no activity like that since, and quite honestly, he didn't think there would be. Basically, the dealer had come in through a girlfriend who had reserved the place on Platinum. She's a Platinum member, so didn't raise any red flags with the staff there that a Platinum member would come in and rent, and then subsequently have another male come in and deal drugs. So it was kind of an anomaly as far as that goes. This is currently active as per our policy, but right now I haven't seen any activity. Any questions regarding the Days Inn? Okay. Thank you.
Chair Baker, I would like to, so Matt Smith is no longer with the city attorney's office, and so we have Melissa Isabel. She can take an opportunity to introduce herself.
Nice to
Great.
meet all of you.
Thank you. And thank you, officers, for your report. If we have no other business on the agenda, we can entertain a motion to adjourn.
I motion to adjourn.
Second.
All in favor? Okay,
Thank you.
Thank you, everyone.
thank you.